My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center. And I am so excited to get us all in the room together to talk about voting in elections. This is a great October class we can all have together. We can learn a lot about what's going on in the courts around elections, but also kind of prep ourselves for the big election month that we're going to begin soon in November. So we've got the two heavy hitters in the room today. We have Jamelle Bouie, who is a New York Times writer, an amazing author around the Constitution and elections, and also a fantastic photographer, which I do follow you on Instagram, and it's super cool to see your work. I love it. I love how you capture history in so many different ways. And then to lead us through this discussion today is our president and CEO, Jeff Rosen. So Jeff, I'm going to let you take it over from here.
Thank you so much, Curry, and welcome, Jamelle Bouie. It's such an honor to welcome you back to the National Constitution Center's Friday classes. This is our first class of the year, and I can't think of a better way to begin. Friends, Jamelle Bouie's superbly illuminating writing is always so deeply informed by history, and he helps us understand our constitutional history in new ways and also understand our current challenges. We're here to talk about voting rights, and we'll jump right into the cases the Supreme Court is hearing this year in a moment. But Jamelle, if I may, I wanted to share with our friends the piece that you just published this morning in the New York Times. We had to force the Constitution to accommodate democracy, and it shows, and in that piece you argue that although we tend to equate American democracy with the Constitution as if the two were synonymous, history makes clear that the two are in tension with each other and always have been. Maybe you could share the argument of this important piece.
Sure. First of all, thank you for having me. I'm glad to be back. This was a lot of fun the last time we did it, and I'm looking forward to our conversation. The column more or less argues, and this is something I've been kind of thinking about for a while, that like you quoted, we tend to sort of think of the Constitution and American democracy as synonymous, but you know, the thing about the Constitution is it wasn't the first Constitution. There is a predicate Constitution. And sort of if you look at the arguments around the adoption of what we now call the Constitution, what you see is a real worry among many Americans, and they obviously lost the political battle, but a real worry that the Constitution would sort of restrain and curb democracy as it had grown up since 1776. And I think that worry captures a core insight, which is that there are democratic traditions and ideas and aspirations, whatever you want to call them, in the US that are a larger category of like political thought than what is contained within the Constitution. And in a lot of ways, the Constitution ends up either moderating or mediating those democratic impulses or even restraining them. And so, you know, to my mind, kind of like the obvious example is that a lot of state constitutions, a lot of states prior to the Constitution had yearly or annual elections for lawmakers, basically thinking that the idea is you want to get as much rotation as possible to ensure that as many citizens as possible can participate in the political process, directly participate. And the Constitution, sets 2-year terms for House members, 6-year terms for senators, 4-year terms for the president, and sort of that became kind of the standard across the country. And although we don't think about it as something kind of like restraining democracy, they thought about it as something that would be restraining democracy, of adding the addition of more time, right, is a limit on the translation of a popular will into actual government policy. And so in the column, I kind of go through this, not that exact example, but talk about the ways in which the various institutions established by the Constitution work in conflict with how Americans have tended to understand democracy over the course of their history. And the example I use is just the political party, right? The Constitution doesn't make and it doesn't even acknowledge the existence of political parties, but they emerge very quickly in the American political system, and they kind of fundamentally restructure how that system works. And they make it more democratic, right? They bring more people in, they change the nature of representation in ways that the framers didn't really anticipate or consider or even necessarily like as it was happening. And the example of the political party, I think, is a signal example of how Americans have basically had to sort of like hack the Constitution in ways to kind of like allow the democratic culture that grew up in the United States to flourish. And the question I think we're facing today is whether or not the Constitution as it exists contains room for expanding democracy even further, or whether we do have to just like actually start making structural changes insofar that we want American democracy to be as robust as it can be.
Wow, thank you so much for that. There's so much in what you just said. And you reminded us that the framers had embraced this principle when annual elections end, tyranny begins. James Madison quoted it in Federalist 53 itself, but then the actual Constitution adopted a different system of elections. And then you call our attention to the central divergence of political parties with the framers' original expectations. They thought there'd be no parties or factions, and they quickly arose. And then you flag all these questions about whether democracy as it's being practiced now through the political parties and elsewhere can be reconciled with popular sovereignty and the rule of law and the will of the people. So much in there. Friends, you now, I hope, will be inspired to read Jamelle Bouie's piece from this morning, and also all of his columns, because there's so much to learn in each of them. Well, why don't we plunge into the voting rights case that the court is hearing? Section 2 of the voting rights is such a complicated area, and this case is so hugely important and really could transform the Voting Rights Act and eviscerate Section 2, which Congress passed in the 1980s to ensure that minorities could elect representatives of their choice. And I wonder what the best way to begin our discussion would be. Why don't you share our friends with why you think this case is important and what the major issues are as you see it?
Sure. Yeah, I think the case is important because the Voting Rights Act has just been kind of slowly. I mean, I'm a partisan in favor of the Voting Rights Act, I should say. So, in my view, it's been slowly eviscerated over the last decade or so. Sort of piecemeal, kind of signal parts of the law. Section 5 in 2013, Shelby County beholder. Section 2 has been sort of chipped away at in the years since. And so I think this case will be another instance of the Voting Rights Act likely being chipped away in important ways. And Section 2 is critical because one of the insights of the authors of the act is that you can't actually treat the formation of congressional districts as kind of like racial neutrality, right? That like one of the tools of disenfranchisement prior to the 1960s was, insofar that Black people could even vote, was to pack them into districts to dilute their voting power, right? If you can pack, if take Alabama for example, which is what this case concerns, 27% of Alabama residents are Black, right? And they are concentrated in the Black belt of Alabama, which runs east to west through the state. Now, if you were to pack all of those voters into a plausibly what's called compact district, then you could essentially dilute their voting power, right? If the state gets 7 House members and you packed all the Black voters into one district, then they could probably elect 1 House member. But if they had not been packed, they might have been able to elect 2 or 3 or form coalitions with other voters. And you don't know how politics works out in that world. And so Section 2 has usually been understood to essentially say, we're going to have these standards for districts. They got to be, what's called compact. Again, they have to have some sort of geographical integrity. They can't be totally wild. They have to, link communities of interest, right? Like different communities that have similar interests in the same geographical region should probably be in the same district together. And when we're looking at race, we're going to take care to make sure that racial minorities have an opportunity to actually elect people who want to represent them. And this is key in the South, where racial polarization in voting is so dramatic, right? Like, 9 out of 10 African Americans in the South vote for Democratic candidates, and like 7 out of 10 white voters vote for Republican candidates. And so odds are, and that's like an average, like in Alabama, it's like 9.5 out of 10, 9 out of 10. It's very stark. And so what you want is basically to make sure that when states redistrict, they're not diluting the vote of those racial minorities too much, because if they are not given their fair share, basically, of voting power, then the odds that they'll be able to elect a representative of their choosing are just very, very low. And in this particular case, the state of Alabama, or the Alabama legislature, produced a map that only gave African Americans like one majority minority district. So packed a bunch into one district and then kind of diluted the rest as much as possible. And the plaintiffs are arguing that this was unconstitutional, that under Section 2 of the Voting Rights Act, what should have happened is Alabama should have created a second majority Black district, accounting for population changes, and giving those voters an opportunity to elect a representative of their own. And the state of Alabama, or the Alabama legislature, disagrees.
Such a great introduction to this crucially important and complicated area. That language you used, do Alabamans have opportunities to elect representatives of their choice, is so crucial, because that's the language that the Voting Rights Act adopted, as you said. And it was in 1982 that Congress decided, just to provide some background, and I always have to repeat this because it's so complicated, I need to repeat it to make sure I understand it. But just to go back to 1982, what was going on? So the Supreme Court had just held in a case called White versus Register that voting arrangements that weren't explicitly intended to discriminate against minority voters didn't violate the Constitution, even if they had the effect of making it hard for minority voters to elect representatives in their choice by being packed or placed in just a few districts, for example. So the question is, how do you decide when you need to create more majority-minority districts for the benefit of minority voters? Congress refused to say you have to have proportional representation that allow minorities to elect representatives in proportion to their numbers in the population as a whole. But they did say that when there's not an opportunity to elect representatives of their choice, you should create another district. The Supreme Court, and this may be too much detail, but as you respond to me, then you can kind of help our friends understand what the stakes of the case are. The Supreme Court had adopted a test for figuring out when you need to adopt another majority-minority district. And it came in a case called the Jingles case. And the test was, is the racial or language or minority group large and geographically compact enough to be a majority in a single member district? Second, is the minority group politically cohesive? Do the members tend to vote similarly, as you said, minority voters do in Alabama? And third, the majority votes are sufficiently as a block to allow it usually to defeat the minority's preferred candidates. Is there racially polarized block voting, so the majority is going to defeat minorities? When all those conditions are met, then you're supposed to create another majority-minority district, which is exactly what the court in this case ordered to happen. And that's why Justice Kagan began the oral argument by saying this should be an easy case. According to our precedents, it was right to create another majority-minority district. But the challengers seem to be arguing you can't take race into account at all. And as long as you just let the chips fall where they may, and by being completely race neutral, that should satisfy the Constitution. And in other words, you're not allowed to do what the Voting Rights Act says you have to do. And in that sense, Section 2 might itself violate the Constitution. Do I have that right? And take it from there to explain why the stakes in this case are so high, because the conservative majority might say that you can't take race into account at all in drawing voting districts.
Right. I think you have that right. That sounds correct to me. And the stakes are high for exactly the reason you described, that if the court sort of doesn't just issue a ruling on the merits, right, but sort of like makes a judgment about whether or not Section 2 is constitutional, and decides that it's not because it requires the use of race to adjudicate, when they create a new district. That I mean, in my view, that more or less sort of neuters Congress's ability to respond to racial discrimination in voting in a robust way. One of the, Jeff, as you alluded to, all of this is like very complicated, and so I feel like there's a little bit of background is needed here. So during the Jim Crow era, Jim Crow states got very good at finding facially neutral ways to impede the ability of African Americans to vote or basically like act as political actors. That, you know, the 15th Amendment still existed. Like they couldn't do a direct violation. This was tried very early on in the Jim Crow period, like just directly violating the 15th Amendment, and that just didn't fly. And so states came up with a variety of ways basically to get around the Constitution's clear prohibition against racial discrimination in voting. And so what's innovative about the Voting Rights Act is that rather than respond sort of on a case-by-case basis, the act is structured to basically try to preclude as much of this as possible, right? To set down rules and regulations and restrictions that like prevent states from even beginning to go down this path. And so if Section 2 is found to be unconstitutional, that would imply that that's just not a thing Congress can do anymore. And in which case states should be free, if they wanted to engage in forms of gerrymandering, in other kind of like election, rule changes that prior Congresses and prior courts recognize as being racially discriminatory. But if the state can have some sort of like on its face neutral reason for doing it, then it would pass constitutional muster. I should say that in oral arguments yesterday, Justice Jackson made the point that the 14th Amendment was not written, or the 15th, I mean, obviously the amendment, but the Reconstruction Amendments on which so much of this rests were not written to be racially neutral. The clear background to the constitutional, those amendments, and then the constitutional basis for the laws passed in this period, the Civil Rights Act of 1866, the Civil Rights Act of 1875, the Enforcement Acts of 1870, 1871, all those things had race at the foreground. This is a part of what lawmakers were directly responding to, efforts to restrict the rights of the formerly enslaved and free Blacks as well. And so if you're going to take a historical reading of this, if you're going to take, I guess, an originalist approach that's trying to figure out what's right here, Justice Jackson made the case that like an originalist reading would say that the Congress has the power to use race in determining these sorts of things, because that is what was intended and that was what was understood at the time.
I'm so glad you highlighted Justice Jackson's significant comments in oral argument yesterday, and I'm going to call them up because they're so important for the reasons you said. Here she is, and this is Justice Jackson in one of her first oral arguments or on the bench. She says, I understood that when we looked at history and traditions of the Constitution and what the framers and the founders thought about, and when I drilled down to that level of analysis, it became clear to me that the framers themselves adopted the Equal Protection Clause, the 14th Amendment, the 15th Amendment, in a race-conscious way. They were trying to ensure that people who had been discriminated against, the freedmen during the Reconstruction period, were actually brought about equal to everyone else in society. I looked at the report submitted by the Joint Committee on Reconstruction, and the report says the entire point of the amendment was to secure the rights of the freed former slaves. And she goes on, and Jamelle Bouie, this is really remarkable because it's, of course, there are always strong arguments on both sides of any constitutional question. But what Justice Jackson is saying is that the claim that the 14th and 15th Amendments require complete colorblindness across the range of state action is not supported by their original understanding. And she gives examples of that. And there's lots of other examples too, that the 14th Amendment wasn't even meant to apply to political rights at all. It was only meant to apply to civil rights. So in that sense, is it right? I understand Justice Jackson to be saying that if the majority essentially strikes down Section 2 of the Voting Rights Act, as it struck down Section 5 of the Voting Rights Act, in the name of the claim that the 14th Amendment is supposed to be completely colorblind, then it would not be consistent with the original understanding of the framers, and therefore would violate the very methodology that the conservatives claim to embrace. Is that the way you see her argument as well?
That's how I see the argument as well. I think she's essentially saying that if you're going to be consistent with your method of argumentation, then you have to uphold Section 2 on this basis. I want to just add my own commentary here. often when doing this sort of historical analysis for the sake of legal arguments, there's a strong focus on documents, right? Like a strong focus on the words and actions of elites. And that has its place. But what's sort of important about more, I guess, traditional historical methods and taking kind of a full picture of the period is that really does help you inform what the context of all this was. And although it feels strange to have to emphasize, right, the context of the 1860s and 70s, during which these amendments are written and ratified, these laws are written and passed, is not just the Civil War, but this like really titanic struggle over slavery and the role of the now freed slaves in American society. Prior to the war, there was no particular consensus on like what would you actually do about a large population of free Black people. It just wasn't a thing that people thought about. It's why one of the more mainstream positions was colonization. I guess if we end slavery, we'll just like either ship them out to Africa or take some territory out west and like ship them to their own state where they can do their own thing. No one within white society, at least, there was no real consensus position about what you do. And so after the war, that is kind of the one of the titanic political struggles. What do we do now that slavery no longer exists? That these people exist in a new kind of social relation. And so all of the lawmaking, all of the constitutional arguments, all of this stuff, like the backdrop is race. Everyone understands it as being, these are questions about sort of like, what relation does race have to American citizenship, right? And this would come up not long after this period over the fight of the Chinese Exclusion Act, right? Like the question of from the end of the Civil War, really until the beginning of the 20th century, what is the relationship of race to American citizenship and American belonging is like the thing. And so in my view, it's not just that the actual documentation would suggest that the Constitution, at least on these issues, is not colorblind. But it's hard to actually understand what is happening in American history in that period if you take the view that what everyone thought was that things are supposed to be colorblind. This is not, in fact, what the cultural and legal and political disputes were during the time.
So important to call our attention to that broader context. And as you say, the debate about colonization was just one of the many efforts to figure out what happens next, and to claim that debate was taking place in a colorblind perspective is, you say, hard to support. Let's just address the argument on the other side, and the passage that conservatives and originalists and others often cite in defense of colorblindness is Justice Harlan's famous dissent in Plessy versus Ferguson, the case that upheld supposedly separate but equal railroad cars. And I was going to call up Harlan's language. I won't do the whole thing, but the famous passage is something like, our Constitution neither knows nor tolerates classes among citizens. In respect to civil rights, our Constitution is colorblind. There is no caste here. Was Harlan making a broad claim that no laws can take race into account, or just with respect to things that were recognized as civil rights, like the right to travel or to make contracts and so forth, that white and Black people had to be treated the same?
I mean, I very much take the latter position. Part of this is that, like, if I remember this correctly, Harlan was like supported Chinese exclusion, which kind of like, if that's the case, and he clearly didn't have a view that things had to be completely colorblind, of course, from the bad perspective, but like it's still relevant. But the other thing, I mean, this again gets back to context, right? Like the context here is that prior to the laws mandating segregation on trains, Congress had passed in 1875 a Civil Rights Act that attempted to sort of prevent segregation on what we would call public accommodations, but sort of trains, theaters, that kind of thing. And even although the Supreme Court more or less neutered that law, there was no formal, like, legal sort of requirement of segregation. So on paper, at least, there was no recognition of sort of like Black Americans as like a lower caste in society. And so like Harlan is writing, in my view, against the recognition of inferiority, right? Like not saying, this isn't a statement that in no way should the law or should the Constitution recognize the reality of race, of like racial bias, of racism, all these things, but to say that we should not be creating different classes of citizens. And when you legalize segregation, you are creating different classes of citizens. And I think this thing should be understood as distinct. And I'm not going to kind of speak for Harlan or anything, but in my view, I think this should be recognized as, precisely because of the context in which the Reconstruction Amendments are passed. I think that should be recognized as a distinct thing from using race to undermine these distinctions of, caste, right? Like it's to say that Black Americans have to be segregated on trains. It's a legal thing you can do because they are of like a lesser class of citizen is actually a categorically different thing than saying we're going to pass these laws to ensure that Black Americans have equal access to X, Y, or Z, right? Like they both take race into account, but taking race into account in order to equalize status among citizens is a very different thing than taking race into account in order to create distinctions of inferiority and superiority among citizens. I think Harlan was talking about the latter. And I think that when we are thinking about the Constitution of race, that's the distinction we should be thinking about. Not whether race is considered, but what is the manner in which it's being considered and whether that is consistent with what the Reconstruction Amendments in particular were actually trying to do.
That's the whole core of the issue. You put it so well. It's not just taking race into account. It's the question of the purpose of taking race into account. And you're absolutely right. That crucial word you used, unfriendly. That was a word that Harlan used in his dissents, both in Plessy and in the civil rights cases, where he was the lone dissenter from the court's decision to strike down that Civil Rights Act of 1875. And Harlan noted the words of the amendment are prohibitory, but they contain a necessary implication of a positive immunity or right, the right to exemption from unfriendly legislation against them as distinctly colored, exemption from legal discriminations, implying inferiority in civil society. So that's the nub of it. It was not a claim that you just can't know race or can't take account of race. It was that you can't imply inferiority in society with unfriendly legislation. And that's the nub of the dispute between the colorblind justices and justices who think that the question is whether the laws are unfriendly and imply inferiority and are caste affirming. And that's why this debate that we're having, that we're sharing with our friends, is so important also for the affirmative action cases, because it looks like the majority of the court is going to hold that because you can't take race into account at all and you have to be completely race neutral, all of affirmative action is unconstitutional. And is it correct that that too would be ahistorical for the same reason that the voting rights decisions would be?
I mean, that's what I would argue. I would argue that under any sort of like context-based understanding of the Reconstruction Amendment, something like affirmative action is clearly constitutional, right? Like you have to, in order for it to be unconstitutional, and this is sort of the approach that's sometimes taken, you have to argue that affirmative action is trying to create create a badge of inferiority for like white citizens. But I think that's plainly not the case. So even if it may not be popular, right? It may not be popular, people may not think it's fair. Under this kind of distinction about the use of race under the Constitution, I think affirmative action is clearly permitted. I mean, there's a much larger conversation here to have about the Reconstruction Amendments, including the 13th, which we only tend to associate with the end of with abolishing slavery, but like there is some argument in scholarship that it's a bit more expansive than even that. But like all these amendments are written to not only address what is the place of freed people in the society, but what are the obligations the national state has to its citizens, and how do we try to encourage equal relations? I mean, kind of a bit of the missing context here in terms of this conversation is that in between 1868, when the 14th Amendment is ratified, and 1865, in the kind of restored former Confederate states, you have what were called black laws, which were explicitly targeted at the formerly enslaved and meant to kind of relegate them to a position not unlike they had under slavery, kind of trying to recreate that social hierarchy through different means. And one thing Congress was very much trying to do, the Reconstruction Congress, or the first Reconstruction Congresses, was to sort of push back on this, to say, basically, we didn't fight this war so that we could put these people back under these conditions. And so how do we structure our government in order to create a presumption of equal status among all citizens? And the 14th Amendment, the Equal Protection Clause, is like very much a part of this story. And so if you just kind of, in my view, if you take that as being like, that's the foundation, then you have a rule for how you evaluate stuff that brings race into the equation. Like, is this something that is trying to ameliorate what were called the badges of slavery, right? Sort of like the set of social conditions and all these things, ideas associated with being enslaved, or is this something that reifies them? If it's the latter, right? If it implies inferiority, clearly unconstitutional. But if it's the former, probably constitutional. Doesn't mean it's prudent, doesn't mean it's correct, doesn't mean it's a good idea, but probably constitutional. And I mean, that's sort of a second order distinction, that like something, just because something's constitutional doesn't mean you have to like it. But it doesn't mean it's like, verboten.
Jamelle, this is such an important debate, and you offered convincingly, because no doubt it was the paradigm case of unconstitutionality. The black codes, the black laws, is an example of exactly what was to be avoided. Those laws denied African Americans the right to make contracts, to sue and be sued. And in addition to violating formal equality, they implied inferiority. They were caste affirming, as if their opponents said. And that's why the 14th Amendment was passed. And I'm just, because it's so helpful to think this through with you, I've just found that first reference to unfriendly legislation was in the Strouder case involving juries, which was really accepted as a unquestionably correct case. That is, here we go. This is, Strouder was selected as part of our Supreme Court library, and the 100 most important cases selected by our liberal and conservative scholars. But here's the crucial paragraph. It quotes the 14th Amendment, and then it's, I think it's worth, let's read this together. I think it's interesting. The 14th Amendment was designed to ensure to the colored race the enjoyment of all civil rights that under the law are enjoyed by white persons, and to give that race the protection of the general government in the enjoyment whenever it should be denied by the states. It not only gave citizenship and the privileges of citizenship to persons of color, but denied the state the power to withhold them the equal protection of the laws. What is this? It's saying, what is the words of the 14th Amendment? But declaring that the law in the state shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the law. And in regard to the colored race, for whose protection the amendment was primarily designed, that's Justice Jackson's point, that no discrimination shall be made against them by law because of their color. The words of the amendment, it's true, are prohibitory, but they contain a necessary implication of a positive immunity or right most valuable to the colored race, the right to exemption from unfriendly legislation against them distinctively as colored, exemption from legal discriminations implying inferiority in civil society, lessening the security of their enjoyment of the rights which others enjoy, and discriminations which are stepped toward reducing them to the condition of a subject race. Maybe at least one more beat on this, because it's so interesting. So, and it sounds like Justice Jackson is going to do this. If you were going to make the originalist dissent in that opinion that we're likely to see striking down affirmative action laws, in light of what we've been talking about, what would it be? Sort of channel Justice Jackson and explain why she's going to claim that the majority is taking the text out of context and applying these words, equal protection, in ways that the framers never intended.
Right. I think so. If I were going to So I would sort of continue along the lines that I have been going. First, I'd sort of make an argument about the actual like political and social context of the time, right? So like this is what was actually happening on the ground. The laws weren't written sort of because it was nice to write them. The laws and the amendments were written in response to specific conditions happening on the ground in the post-war South. And that is sort of should be our basis for understanding, in my view, that our basis for understanding what is actually happening. And then I would point to all the evidence that suggests that sort of like the authors of the 14th and 15th Amendments weren't opposed to the idea of using race as a variable for how the government should act, and doing some way that ameliorates these like the badges and incidents of slavery, right? So like the authorization of the Freedmen's Bureau, the authorization of the Freedmen's Bank, sort of the limited but very real steps taken by the federal government to sort of like assist freed people in ways that were criticized for not assisting whites similarly, right? Like this is part of the argument is like noting what the critics of this stuff said, which gives you, I think, some insight in what the advocates were trying to do. Would kind of be part of my argument that like at least in this period, right, like as you get further away from the war, right, there is this backlash to all of this that people are very much aware of. But in terms of the authors of the law and the authors of the constitutional amendments, it's clear that trying to, and I'm going to use the phrase again, alleviate the badges and incidents of slavery was part of their aim. And so after that, you kind of just have to, I'm not an originalist, right? So I'm not entirely sure how an actual originalist would argue this point, but the point I will make is that even if something like affirmative action did not exist in the 19th century, which kind of, why would it? Because affirmative action is like fundamentally sort of administrative policies, and like the administrative state didn't exist. And so there's like no reason for it to be there. But even if it didn't exist, the principle that underlies affirmative action, that it is legitimate and constitutional for the state to take actions that are meant to equalize what were formerly relationships of inferiority and superiority, that is legitimate, because that is the thing that the authors of the amendments had in mind. That general principle you can see on the ground in real time in the 1860s and 70s and 1880s, right? The very last attempt Congress made to do something about voting rights prior to the 1960s was the 1890 election bill called the Force Bill by its critics, because what it would have done is it would have essentially created federal oversight of voter registration in the South to prevent kind of disenfranchisement of Black voters, like a piece of legislation that its proponents, specifically Henry Cabot Lodge, specifically argued, right, that we're doing this to protect the Black voters of the South under our constitutionally authorized power under the 15th Amendment. And like, to me, that's just dispositive. Like if up to the end of that century, you have lawmakers essentially saying, yeah, we can do this because the amendments that, you know, people that we knew wrote said that we can do this, then the claim that, you know, this was not the intent, to me, just doesn't hold water.
That is such a powerful example and so relevant to the voting rights case. As you just said, the force bills are dramatic examples of Congress using its power under the 15th Amendment in a race-conscious way to ensure equality, and it seems dispositive. And then you give the example of the Freedmen's Bureau, whose benefits went primarily to African Americans and were criticized for doing so. Another example of race consciousness. Should we take? I'm just going to ask for one more beat, because this is where all of the action is on the Supreme Court in terms of the liberal dissenters claiming that the conservative originalists are not being true to their own principles. And if I were going to make the counter argument just as quickly as I can, I guess I would say, with regard to the Freedmen's Bureau, that there was a scholar called Herman Belz, who I read years ago, Balz, B-A-L-Z, Equality Transformed, who said that it's true that most of the benefits of the Freedmen's Bureau went to African Americans, but they were formally also open to white refugees because of concerns that they not be explicitly race conscious. So, and then the force bill, I'm just making this up, but might be viewed as remedial legislation and not race conscious moving forward. I don't know, something like that. Knowing the history as you do, is there any case that these laws like the Freedmen's Bureau and the force bill were formally colorblind and their benefits went mostly to African Americans, or is that not persuasive?
It's not persuasive to me in terms of just because how proponents argued about these things, how they talked about them. But it's also not persuasive because part of what the Freedmen's Bureau and the Force Bill and the two civil rights laws in 1866 and 1875 were doing was just like recognizing the actual experiences on the ground, sort of like not pretending that law happens in this realm of pure thought, right? Of pure reasoning, pure logic. And so it's true, yeah, the Freedmen's Bureau absolutely was not closed off to white refugees. But the name itself, right? The fact that it's called the Freedmen's Bureau, it should give you a clue as to who the lawmakers thought they were trying to help with this set of policies. And in the same way, right, like the Voting Rights Act does not say, right, that this is only to help Black voters. The Voting Rights Act has assisted many different kinds of voters over the course of its existence. If there were a polity, like if there were a state where the majority of residents were Black and they voted in a Black-like way, and they took action to keep the white minority from electing representatives of their choosing, though that white minority would be able to take advantage of the provisions of the Voting Rights Act. The issue, to the extent that white Americans have not been able to utilize some of these provisions, it's because it's just like they just don't suffer from the ills, right? And like it's not a constitutional requirement that all laws passed must have equal effect for everyone. If a law is passed to remedy a specific kind of social ill, and that social ill has racial dimensions, that's just how it's going to shake out in terms of who's affected. But because the laws are typically targeted towards the ill, and not like towards the class of people, right? Like the race is used to diagnose the ill, but race is not used to say who can benefit. If a set of white Americans face the ill, then they would be beneficiaries of the policy, which is kind of a thing that's been true of affirmative action. I mean, it's been widely noted, commented upon that white women have been, beneficiaries of affirmative action for similar reasons that Black Americans have, or that Hispanic Americans have, or that any other underrepresented group have, because it's targeted. The set of policies is targeted towards increasing representation of underrepresented groups, not necessarily to, if you're Black, you get in, or whatever the case may be.
So powerful. Not a constitutional requirement that all laws have equal effects for everyone. If you face the ill, you can get the benefit, and your insistence that we look at how the law actually operates in practice rather than taking place in pure thought. And Niels Nielsen in the chat says it's so refreshing to hear Mr. Bouie speak about the full context of the past when the Supreme Court is simply wanting the reading of history. Can that be a basis for their handing their decisions now? I'm learning so much from this exchange, as I always do, Jamelle, from our conversations. But let's step back now and say, how would this look like in history if, as is widely expected, the U.S. Supreme Court essentially strikes down Section 2 of the Voting Rights Act, having already struck down Section 5, and also strikes down affirmative action? That follows on a court that struck down, as you said, the Civil Rights Act of 1875 that upheld segregation, that eviscerated the Privileges or Immunities Clause in the Slaughterhouse case. What does that say about the Supreme Court's performance when it comes to these landmark race cases?
So people may describe me as a little bit of a cynic about this stuff. My view is that this would be in keeping with how the Supreme Court has typically behaved when it comes to these sort of cases. I mean, we've kind of already gone through the list. But the mid-century run of Supreme Court decisions that kind of enhanced civil rights, that protected voting rights, sort of like began to dismantle racial caste in this country, are like kind of an exception to the rule. That prior to that, beginning with Dred Scott, right? Beginning with the holding that African Americans could not be citizens of the United States, and continuing with the civil rights cases, with the slaughterhouse cases, continuing with Plessy v. Ferguson, continuing into, right, I forget the exact name of the case, but the case that sort of held that racial zoning and land use was unconstitutional, but like freed up basically localities to develop forms of zoning that accomplished the same purpose, just didn't explicitly label race. The Supreme Court has
Hannon and Woodley, I think,
yeah. The Supreme Court has not historically been that much of an opponent of efforts by local and state elites to create racial distinctions against racial minorities. And my sense is that if this court continues to dismantle kind of the signal legislation of the 60s meant to address these things, what we'll see is maybe not something as dramatic as what existed in the past, because social mores have changed. I mean, there has been progress in the country. But how I interpret all of this is basically the court carving out space for states to if not impose badges of inferiority, to at least use the logic of partisanship to begin to cut out groups of people out of the electorate. Not directly, you probably couldn't get away with that, but at the very least, tremendously weakening their voting power, leaving people kind of like unable to shape their political circumstances. So, for example, in Alabama, if these maps are upheld, then it's if Section 2 is struck down, then it's not just that we have this group of Black Alabamans who won't be able to elect a representative of their choosing, thanks to being packed compactly into this one district. But as the state changes, as districts are redrawn in the future, if the Black population grows, for example, the state will be free to take even more dramatic steps to prevent the growth in a Black population from translating into political power. The Supreme Court is already more or less taking a blind eye to the kinds of hyper-partisan gerrymandering that effectively relegate, in a place like Wisconsin or North Carolina or Pennsylvania, effectively make it so that a numerical majority of the state, if they do not live in kind of like the rural areas, cannot elect a majority of the legislature, just like it cannot happen, thanks to the way the states are gerrymandered. Striking down Section 2 would give states license to begin to tinker with, do this along the lines of race. And we know that this is going to happen because maybe this was 2 years ago, 3 years ago, there was the big expose, I think in the New Yorker, about the map maker for conservative politicians whose own method specifically looked at the racial distribution of voters in order to determine how you're going to gerrymander and how you're going to solidify power for his chosen party. So I think that, like, to the extent that, to borrow a metaphor that Ruth Bader Ginsburg used in her Shelby County dissent, to the extent that we have not been seeing these sorts of attempts to, if not restrict the ability to vote, then restrict the actual voting power of a set of voters, is because we've had this like very big umbrella, right? Sort of like basically stopping the states and stopping localities from being bad actors. But as we've piecemeal sort of taken that umbrella apart, we're seeing that if not for racial reasons motivated by racial animus, and at least for reasons motivated by partisan attempts to win partisan power, right? Like partisan advantage, that people are going to look for ways to weaken the power of voters who don't support them. And that kind of, to my mind, if American democracy means anything, it means something like political equality among citizens. And I think these rulings should like really strike at the idea that there is anything like meaningful political equality among citizens.
if American democracy means anything, it means political equality among citizens, a very succinct, powerful, and true statement. For me to turn things back over to Curry, Jamelle, I could go on just, for a long time, because I always learn so much from our conversations, but we always end on time here. And Curry, I know our friends have lots of questions, and I just jumped right in with Jamelle Bouie, so there may be some basic questions about voting rights and elections that you want to pose before we close. Back to you, Curry.
Well, our class does end at 1:30, so we're definitely not keeping that time.
I couldn't resist. It was totally worth it. It
No,
was so wonderful.
I knew I was, as soon as Jeff screen shares, we know we're in it for a while. So I think it was great. The students are always so excited about all the cases that you both went through, and the Voting Rights Act, and really unpacked these stories. Jamelle was talking before we got on that, it's hard to tell these stories because you really have to go back to the history, and you both did that so well. So 2 of our student questions for you. So we have the Corey Loyola social justice class is with us today, and Bevan from that class wanted to know how other powers can be used to check the powers of the Supreme Court regarding SCOTUS decisions.
So I've written about this, and this is a thing that I feel like maybe I'm becoming known for. I don't know, but my view is that I should get, like, my broad view is that I think we tend, especially in the past 50 years, but this wasn't always the case. This is a relatively recent development in how people think about the Supreme Court. But people tend to think about the Supreme Court not as if it's part of the constitutional system, but as it somehow sits above the constitutional system, that it is actually adjudicating disputes within the constitutional system. But I think it's more proper to think of the court as part of the system of checks and balances, which means that it checks, but also can be checked. And I think the Constitution provides like clear remedies for elected officials who believe that the Constitution has overstepped its bounds. This comes to another view that I have, which is that because Chief Justice Marshall, famously said that it is the duty of the court to say what the law is. But I do not think that means that the court has the exclusive right to say what the law is or what the Constitution means. I think that actually is a thing that is shared among the branches and among the people at large. And so if the other branches, channeling the people at large, think that the court is advancing interpretations of the Constitution that run counter to theirs are, I think those branches have some options. One of them is to and this is the authority for this all comes from Article 3, Section 2 of the Constitution, is for the Congress to sort of like limit the jurisdiction of the court, to say that on at least this set of issues, you can decide cases, but your rulings don't necessarily have to be binding over the entire binding as constitutional law. This is kind of the approach that Abraham Lincoln floated in his first inaugural, right, or in the Lincoln-Douglas debate, but then it comes up again in the first inaugural, which is to say, Dred Scott, which is the ruling in question, Lincoln said, the court is fine to adjudicate the particular dispute between Mr. Scott and Mr. Sanford, but I don't think that decision has any bearing on what the law is. And there are ways to sort of codify that in Congress. We discussed earlier, Jeff mentioned, in 82, when Section 2 was written, the law Congress passed was in response to a Supreme Court decision. And this is kind of what that is, right? Not stripping away jurisdiction, but the Congress essentially saying, we think the court got this wrong. So we're going to pass a law basically saying as much and ensuring that this is what the interpretation is. Other things I think you can do, at least when it comes to the court's relationship to federal law, is there's nothing in the rule book that says that you can't change the threshold for when the court can overturn a law, right? So right now it's just a simple majority, 5-4, and there it goes. But Congress could pass a simple law that says, well, for this set of cases, or for cases involving, duly passed laws of Congress, it has to be 6-3 or 7-2 or 8-1. The rationale being that if the Congress And if the president and if 4 justices, right, say that something is constitutional, then that should have real weight. Five people shouldn't be able to simply outweigh all of that. Those are 2 things that immediately come to mind, and the latter of which I like the second option a bit more than jurisdiction stripping, for the simple reason that it actually is like a real structural change. So I think it would actually change the behavior of the justices, and it would, I think, enhance, it would both be an attempt to, in some respect, weaken judicial review, but also sort of like make it all the more noteworthy when something is overturned, right? Like if you are a justice and you know that, okay, if I want to invalidate this, if we think this is unconstitutional, then we need to have consensus, not just like a bare majority. We need to have like actual consensus among the justices. I think that sort of like introduces the right kinds of incentives to judicial decision making versus what I think we're seeing now, which is very much like, can we get to 50+1? Yes, then let's let it rip. I think that approach does much more to destabilize the court than a high barrier for decision making.
Thank you for sharing that. We have talked about this kind of general concept a lot in these classes, and I don't think any of our other scholars have ever put that on the table as a, hey, here's a way to do this. So thank you so much for bringing that up. One final question from David Kendrick's class, who's with us today. One of the students asked, why was the amendment and that concept around the amendment so much about colorblind? And there wasn't a lot of references, and we're probably talking about the 14th Amendment and the cases around that, but not gender blind as well.
I mean, so is the question, because I don't think those amendments were colorblind. They very much took account of race, but they did not take much account of gender, and no one involved really thought much about, obviously women could not legally, had no constitutional right to vote. It's kind of enacted that women couldn't vote. There are places that could vote, but there was no constitutional grant. So states could pass laws saying women can't vote. And that's just like, American society in the 19th century was like highly patriarchal, extremely patriarchal. And women were still, especially married women, were still in a lot of ways like property of their husbands. And the social relation of women to male society, to men, was a subordinate one. And they're really, outside of sort of like activists, outside of sort of like reformers, and even then reformers on what we would identify now as like the left, there was no attempt to there's a mainstream effort to sort of like change this. Even the suffrage movement was like still tied up in like middle class and what we come to recognize as like Victorian notions of like a woman's place. And so that's kind of the immediate answer. Having said all of that stipulated, there's a very interesting argument, like somewhat at this point a little old one, by a scholar named Peggy Cooper Davis, I think is at NYU, who argues that although gender is not a part of the 13th and 14th Amendments, and certainly not the 15th, that nonetheless the authors of those amendments were very much aware of the gendered nature of slavery, right? That like part of what slavery entailed was the destruction of familial relations between husband and wife, between mother and child. Slaveholders prevented families from forming, prevented the bond between mother and child from forming, selling children away, and then also forced women to give birth, right? Sort of forced, used their authority to force women into this position. And so her argument is that if you take seriously that the authors of these amendments were aware of all of this, and they were, part of the reason a book like Uncle Tom's Cabin becomes such a sensation, right, is because yes, it's fiction, but it provides like critical information to people, confirms things for people. And one of the recurring scandals, and the abolitionist press made use of this, was it was called white slavery, and they would like circulate pictures of mixed race children who looked like, who looked white, who were enslaved because their mothers were enslaved and their fathers were a slave master or an overseer or what have you, and say, well, this is what's happening down there. I mean, I'm putting it in like modern terms. Like, it's basically what they said. Like, you're living your life as a farmer in Vermont, and so you have no reason to know about this. But let me point you to what is happening down there. It is sort of like sexual exploitation on a scale you cannot even imagine. And politicians were aware of this in the North. This is like part of the popular energy against slavery that develops in the 1850s. Is very much tied to like a revulsion against like these sorts of stories. And so Davis argues more or less like, if all of this is true, if this is the thing that people are aware of, then there are, those amendments have some gendered implications that we need to begin to tease out about what exactly they prohibit in terms of the domination of other people. And my own view is that you could make a case for at least the protection of abortion rights, basically on the grounds that the state forcing someone to carry a pregnancy is a kind of bondage.
Thank you. That fantastic question from Dave, the classroom. Great questions from the students all along. Fantastic conversation. So I'm so happy we went over time and doubled our time. Thank you for staying with us so much. And I just wanted to kind of pull out so many big ideas that you both shared during this class. It was, first of all, fascinating to watch you both discuss the arguments in the cases, how you frame an argument, how you cite your argument, and then how you make that argument stronger to really prove your point and move people to your side. So what a great class this was as well for our students to understand the process of writing an article or writing a case brief or writing an argument for the Supreme Court. So thank you so much for that. But I love the questions that you share with our students. You should ask, what is the purpose? You should ask, what is the outcome? And create a presumption of equal status. All these great, big ideas from this. And then I have to say, my favorite must have been, just because it's constitutional doesn't mean you're going to like it, which I really appreciated as well. That's something to remember. Like, things are in the Constitution and you may not agree with them. And there's different conversations we have around that. Thank you so much for teaching our class with us today. Jeff, thank you so much for leading us through all these stories and helping us get through these really tricky court cases that are in front of the Supreme Court this year. Thank you both.
Thank you, Curry. Thank you so much, Jamelle. It's always just such an honor and privilege to have you on, and can't wait for the next time. Thank you very much.
The pleasure is mine. Thank you so much.
Great.
Thank you, everyone.
Bye, everyone.
Have a great Friday.
Bye.